Elville and Associates presents the Elville Client Continuing Legal Education Program. Preparing for Long-Term Care, presented in association with Crump Insurance and Trinity Washington University in Washington, D.C. Elville and Associates engages clients in a multi-step educational process to ensure that estate planning, elder law, and special needs planning work from inception throughout lifetime and at death. Clients are encouraged to take advantage of the planning team concept for leading-edge, customized planning. The education of clients and their families through counseling and superior legal technical knowledge is the practical mission of Elville and Associates. The following presentation is for educational purposes only. It is not intended as legal advice or as a substitute for legal advice or legal counseling and does not create an attorney-client relationship.
I'm going to lead you through a discussion of about 30 minutes about elder law issues. So some of this is pretty heavy material, and I'm going to just give you the surface of it, and we'll get into questions and answers or a discussion later, whatever is best. So I'm an elder law attorney. I'm an estate planning attorney as well, and we do special needs planning. So we do that hybrid kind of practice, and so we see a lot of different types of situations, and I'm here to be an educational resource for you this morning. So let's get into this discussion, and I'm going to move quickly so we can cover everything. Now, the current landscape in elder law. Do any of you live outside of D.C.? Okay. Virginia, Maryland? Okay. So I'm going to talk to you about Maryland because that's where our main offices are, but the issues are similar everywhere, basically. So the trends in Maryland planning, for example, Maryland is a very liberal state with regard to Medicaid planning. What does that mean? It means that it's pretty easy to get Medicaid for most people. When we're talking about Medicaid, we're talking about a program, state and federal government. The Trump administration is talking about changing this, so we have to be careful here about the possibility of change. But we're talking about something that finances about 85% of all the long-term care in the nation. So this is a huge program, very expensive, but Maryland is very liberal. Maryland is also very liberal in how we can preserve assets. So some people are worried about preservation of assets, asset preservation in long-term care. So we have conventional asset protection. For example, your 401k or your IRA is protected from the claims of creditors. But we're talking about a different kind of asset protection here. We're talking about long-term care asset protection. A little bit of a different thing to think about. So Maryland is very liberal. Federal law and the Affordable Care Act. So you probably have read about this every day, and you know what's happening here. I won't spend a lot of time on this. What is the biggest risk? The biggest risk is that the federal government is talking about the way it's going to finance long-term care on the federal and state level. So we may see changes in the future. We won't get into it today. Block grants and per capita grants, the way it's financed. Now that doesn't mean that the way people qualify for long-term care or community-based Medicaid is going to change. That may or may not change how they qualify, but the sources of money and how it's financed at the state and federal level, that's what's being talked about. In Maryland, the greatest thing we're worried about is the loss of waiver programs. And in DC, I'm sure you have your own waiver programs here, but I'll speak to Maryland. Let's pretend that we have three types of Medicaid. I'm just setting the stage. Very simple way of thinking about it. We have community-based Medicaid. This is the kind of situation where I'm impoverished, I need health care, I need social services benefits. That's community-based Medicaid. Think about that as unlimited. Over here on this side, we have long-term care Medicaid, skilled nursing care. That's also unlimited. That's a different world over here. And here in the middle, we have what we call waiver programs. This might be the older adults waiver, we may call it in Maryland. It could be a brain injury waiver. It could be an adult daycare waiver. These are programs that the federal government says to the states, you can figure out how many slots you want to provide. So one of the problems we have with the potential repeal of the Affordable Care Act is the loss of huge amounts of money in waiver programs that could hurt people who are on the waiver program. So that's one of the things we're very concerned about. So major problems, as we got into this just a moment ago, waiver slots. For example, Maryland has very few waiver slots, only a few thousand. And what does that mean? That means that, well, there's 25 or 30,000 people on the long-term care waiver slot list alone, just in long-term skilled nursing, 25 or 30,000 people on that list. How many people got the waiver last year? Only about 148 people out of 30,000. So you can see this is already a very stretched program, and it might get worse. So we're hoping those waiver slots don't get cut. Augmented estate. What does this mean? We don't have time to get into this morning too much, but it just means this. In Maryland right now, when we are doing planning, we can minimize the amount that the state can recover in a spousal situation. We can minimize the amount that the couple can lose to state recovery. So let's say I'm in a nursing home and I'm a single person. The state of Maryland can place a lien against my house. They can go after my estate to try to recover what they've paid for me, for my benefit. And that makes sense, I guess. But between couples, we're worried about how is the well spouse going to be able to survive in the community. So there are techniques in planning that can be used now. The augmented estate legislation would say this, and we don't have time to get into this, and I apologize. The augmented estate says, well, we can't protect quite as much because what is considered part of the estate is more than just what goes through a person's will. It is their IRAs, it is monies that pass by joint ownership, it's all kinds of things that pass at death, and not just the estate, the will. So this augmented estate is a broader version of the estate, and Maryland is looking at this, and if they pass it, that means that we are going to be able to preserve less, and hopefully there'll be a compromise there. Just like on Capitol Hill, there's always these compromises. So augmented estate legislation is one of the things that's on the table in elder law. So cost of care continues to go up, and of course elder abuse is an ever-present issue, and financial elder abuse is really on the rise. So that's something we have to be aware of. All right, now the first step in thinking about planning for long-term care and planning for elder law in general is to think about the legal aspect, okay, as far as where we're coming from with documents and legal strategies, okay? So if I'm older, or, and this is not just if we're older, this applies to anyone, but let's talk about elder law. If I'm getting older or I have older parents, what do I want to make sure of? Well, first of all, I want to make sure they have an advanced medical directive, okay? I want to make sure that they have agents. Could be you, it could be siblings, it could be other people. And we want to make sure that we're avoiding guardianship. We're going to see a slide here in just a moment. So when we have an advanced medical directive, we are making end-of-life decisions in advance. We are naming agents. And the underlying thing we are doing is we're trying to avoid guardianship of our person. Because if we have a guardianship over us, what happens? A court is in charge of our lives, and we lose our legal rights. So the last thing we want to deal with is guardianship. So guardianship can be avoided as long as the family gets along. Guardianship can be avoided with these documents. On the financial side, we want to use powers of attorney. Now, DC has a statutory form. Maryland has a statutory form. So you'll see this up here, Maryland statutory power of attorney. That is a very basic power of attorney. But basic powers are not necessarily the only thing we need in elder law. If I'm going into the future and I might have to do asset preservation, or I might have health issues, or I want my children to be able to seamlessly take care of anything that could happen, do I want broad powers or narrow powers? I want broad powers. So in a perfect world, we're going to give all kinds of flexibility to our agents in these documents and in this document to avoid guardianship of the property, guardianship of the person. And of course, people should have wills or trusts as their basic estate planning documents. And wills, as I mentioned with the augmented estate, although we don't have time to talk about it in full, wills can be used by federal law to help preserve assets in spousal situations. So there's certain ways that can be looked at depending on the situation. So basic estate planning structure, going into the future, if you or your parent or loved one has mental capacity and they can sign these documents, I would advise you to have them sign documents as soon as possible. That is critical, so that in the future you do not have to go to court and be a part of guardianship proceedings. All right, so a revocable trust, we're not going to get into this much, but this is what an alternative to a will looks like. You see that the trust is the driving force, plus you still have advanced medical directives and powers of attorney. what does this have to do with elder law? Probably not a whole lot, except that a lot of people who come to see us will have a revocable trust. I was meeting with a man yesterday, and he had a revocable trust, but his wife has kidney failure. She has a revocable trust, and the question is, for elder care, are we going to keep that conventional estate plan, or are we going to switch to a different elder care focused estate plan? So sometimes these are traditional estate plans, but they might change with elder law issues that are happening. What would I take away from that last slide? That we have to be flexible. Most people do estate planning documents, and they never revisit the planning. So let me give you a little trick question. About 55% of people do no planning across the country. I'm talking about estate planning. That means only 45% of people actually do planning. Of the 45% that do planning, how many years go by between visits when they go see their lawyer again? 10, 5.
I'd say about 1 or 2%.
1 or 2%. Good guesses. The average that we know about is 19 years. So the average person only updates their planning 19 years at a time. So can you imagine, is there a possibility that that plan is going to fail? Yes, because people do not keep their planning updated. So when we're looking at that revocable trust slide, the thing to remember is, no matter what planning you've done in the past, no matter what planning your loved ones may have done, the thing to do now is to update. Hopefully they are not mentally incapacitated. If you do planning, or your loved one does planning, and they keep it updated every 2 or 3 years, their planning is going to work. Okay, this is just an illustration of the increasing importance of avoiding guardianship of the person and property, and this is what these documents do. That is a key in elder care planning. All right, now, in any estate planning or elder law, there is a gap, and that gap is usually there's no long-term care product that the person owns. So you could have the greatest plan in the world. We could go to the most expensive lawyer here in DC or New York, and we could do a wonderful estate plan. But if we haven't plugged the gap of long-term care costs, we're still exposed to downturn in our assets, or spend down of our assets. So I'm going to show you here, and just really mention this, and Chuck and Rick can speak to this, because I'm not a financial advisor or an insurance person, but this is critical. When I was a young lawyer, very, very few people had these products. Very few people even thought about doing this. But as the years have gone by, you're going to want to visit or revisit long-term care insurance products, or what I'll call hybrid products, insurance and annuity products that are designed to make it easier to get long-term care coverage. This is a major gap that needs to be plugged in most people's plans. And when I show you these other strategies that we get into, remember that these are strategies that most people have to rely on because they don't have this. Okay? So the Medicaid strategies are wonderful. They're there for a reason, but they're very expensive. Here's an example. If I'm dealing with someone who is ill, they have dementia, they may be married, we have to do a spend down of their assets because we don't know what else to do to protect them from nursing home costs of $10,000 or $12,000 a month. This might cost 40% in income tax to cash out their IRA or 401k, which in Maryland is an asset that's countable. So people that do well saving for retirement, those people are sometimes hit the hardest if they have to do a long-term care spend down. So if you have these products, you can avoid having to cash out those kind of assets. Okay, so I just want to make that point. Now, knowing that that's where we really want to be, I'm going to leave that up to Rick and Chuck to talk about that, but I'm now going to go into the legal strategies, okay? All right, so legal approaches. Let's understand why people come to see an elder law attorney, okay? Well, it's usually age related, okay? I mean, most people when they're 60 don't come in. Most people when they're 50 don't come in. Now, do we have young people that are 40 and 50 years old in nursing homes? Yes, sadly, yes. But most of the time it's an older person. Pre-crisis planning. So let's pretend that a couple who, or a single person who did planning with me 20 years ago when they were 50, now that person's 70 or 75, they come in to see me. Maybe something has changed. They've got an impairment of some kind of dementia, God forbid. We're seeing all kinds of things like that. One of the spouses is struggling with something. Now the planning is changing, perhaps, and that we would still call a pre-crisis situation. Either a change of circumstances has occurred, or let's pretend this couple's perfectly healthy. And they say, Steve, we've been very lucky, we're healthy, we're 72, I'm just making this up. And we just want to talk about how to preserve assets for our kids. You know, this might be the discussion that people have. Now, does everybody want to preserve assets for their kids? Not everybody. Some people say, hey, I want to spend the assets on myself. So it's not always preserving assets for the kids, but that's a discussion. So we have pre-crisis people coming in to talk about issues, and we have crisis. My spouse is in a nursing home. My spouse just had a stroke. You know, all of these horrible things that you know about that happen. So these are the things we see in practice. But it's good to kind of get your mind around what is driving people to come see elder law attorneys. All right. Now, the best way I can give you to think in terms of these issues is to say, this is what we talk about in the elder law consultation. When I was a young lawyer, I was taught by a mentor, elder law attorney, this is what you do. When people come in, they need to know an overview. People are scared. People don't know these rules about Medicaid. They don't know what they can do. So this elder law consultation, which is usually about 2 hours, is really designed to give people a broad overview. This is what you're dealing with from a legal perspective. This is what you're dealing with from a financial perspective. Do you have a financial advisor? Do you have a CPA? Try to put this together. Do you have a geriatric care manager who is helping your family manage this care at home or wherever it may be? So this consultation, we get into these issues. Healthcare decision making, okay? In Maryland, for example, we have a changing landscape, I think. We have a relatively old advanced medical directive that was put out by the Attorney General probably around 2010, but we have new MOLST laws, medical orders for life-sustaining treatment. So I see those two at odds, those two things that are in the law, and you have to be aware of what that is. What is a medical order for life-sustaining treatment? How do I best advocate for my loved one? What do I need to know about that? So healthcare decision-making, financial decision-making, how much flexibility do we give our agent? You know, that's one of the discussions we have with people. We spend an hour and a half talking to people just about financial powers of attorney and advanced directives. I have other lawyer friends who say to me, what do you talk to people about for an hour and a half about those things? And just so many issues in elder law to talk about. In-home care management. Okay, we're caring for someone at home. How are we going to afford that? What is the legal liability? How do we do payroll? You know, what is this caregiver's rights? Do caregivers have rights? Yes, these people, they're not really very well paid, and they can be abused, and all these kinds of issues. So in-home care management, nursing home and assisted living placement. I just got a geriatric nurse involved in a case. She went to a nursing home in the Baltimore area and found a horrible situation with an older gentleman who has dementia. He just is not being taken care of. So there's all kinds of issues. Now, are there a lot of bad nursing homes? Yes. Are there some good nursing homes where people are doing a good job? Yes. So working through all these issues, do we need to do a placement? So in this particular man's situation, we're going to place him in another nursing home. Other situations might be someone has had a crisis, they're in a rehab center, but now they need to be placed in assisted living. And that can be challenging, because what happens when someone's placed in assisted living or placed in dementia-focused assisted living? They're not coming out of there. They're going to be taken there and they're not coming out. That's a very difficult situation for the family. So that's what we get involved in. Estate planning, what should we do? Conventional estate planning, or should we do elder care focused planning? Asset protection. Most people want to get into this discussion of asset protection, even if it's just to know the general knowledge about asset protection in the long-term care context. And we talked about liability in in-home care situations. It could be someone who, well, my parent isn't doing that well, and well, gee whiz, just the other night, they drove their car and we couldn't find them for 3 days. The police found them because they have dementia. You know, are there liability issues? And people have these questions. So we talk about that in the elder law consultation. Continuing, nursing home contracts, assisted living contracts. Okay, these can vary. The state of Maryland puts out about 4 approved contracts that govern most of the continuing care retirement communities and assisted livings, but you have to work through those issues with some people. Should I sign this contract? Medical assistance, Medicaid, we talked about how that pays for about 85% of people's care, and how you spend down for Medicaid may determine whether you actually can preserve assets. Long story short on this subject, what do nursing homes want to do? They don't want to lose money. Do nursing homes lose money? Yes, they sometimes lose huge amounts of money because people don't sometimes make full disclosure of their assets and other issues. So what do nursing homes try to do to protect themselves generally? They want all the people who come into the nursing home to immediately apply for Medicaid. And if you apply for Medicaid immediately, you may not do it the right way. So from the legal perspective, you only want to apply for Medicaid in a certain structured manner, in a methodical way, so that you can preserve as much of the assets as possible for the family. So, is the nursing home's interest and your interest the same? No. 2 different interests, and it's a very important thing to remember that. And at a time of crisis and an emotional time, is that hard to, it's sometimes you can forget that. So just remember, legal representation at that time is very important. Medicare, we won't get into that today, but it's a huge, broad area. Special needs planning, that has a lot to do with planning for children and adults with special needs. And there are ways of trying to preserve assets for their use where they can apply or qualify for public benefits and not be disqualified because of assets that they might otherwise own. All right, I'm going to check my time. Oh, we have about 10 minutes. All right, so what is the elder law consultation? We know what we talk about, but it's a fact-finding interview. We're identifying problems. We're identifying clients' goals. We're giving an overview of the incapacity-related issues. Okay, remember, elder law is about incapacity and disability. Let's stop right there for a minute. What is the difference between estate planning and elder law? And I just kind of glossed over this. But the difference to me is that elder law is estate planning with a focus on disability. Okay, so elder law is a buzzword. It's been around for about 20 years, but that's really what it is. It's a focus on disability planning rather than a focus on estate tax and income tax planning. All right, we're trying to identify client goals. All planning in elder law, just like all planning in estate planning, should be driven by client goals. Okay, I could sit up in front of a family and discuss elder law issues for 2.5 hours, tell them everything they need to know, but unless I really identify what their goals are, I'm not really being much of a help to them. I'm giving them a lot of information and no direction. So we really want to be proactive about a solution in elder law. All right, so again, medical assistance, asset protection techniques, cost of care, and this gets back to Rick and Chuck, how to finance long-term care. If we can't finance it personally, then we have the Medicaid system to help us as a backup. But again, it's much better to be able to finance it personally. Discussion of an advisory team. I alluded to this before. One of the things we're doing is saying, okay, do you have an accountant or CPA? Do you have a financial advisor? Do you have a geriatric care nurse? We're trying to be collaborative with the planning team. So if you're facing a crisis, facing tough times, providing care for a loved one, you're exhausted, family members are exhausted, you can seek help. And you can have assessments done by the local agencies. You can have assessments done by a geriatric care manager, which is a private pay situation, but they're relatively inexpensive for what they do. So help is available, and we try to connect you with a collaborative team. And then recommendations and next steps. When I was a young lawyer, I was taught to give people an elder law consultation, and I learned to do that, I think, pretty well. But what I noticed was a lot of our colleagues give people a lot of information and no solutions. And what I know about clients that are in pre-crisis or crisis situations, they're looking for solutions. So what we try to do is stay abreast of all available techniques and laws that people can utilize for their own benefit, even though we have to disclose, of course, that those laws could change, as we are seeing on Capitol Hill. So we do the best we can to plan for today, based on what we know for today. And we want to have a mindset that we can't just plan and forget about it. How many of you do your taxes every year? If you don't raise your hand. I'm just teasing. So you go to your accounting firm or your CPA and you do your taxes. If you have a financial advisor, chances are you talk to them at least once a year. So think about your legal or elder law planning the same way. Don't let it go for 19 years at a time. And of course, that's a silly thing to do, but life is like that. You know, we get busy and we don't think about it. A healthy way of thinking about it is plan, maintain, and then the plan works as intended. Okay? All right. Now, on elder law consultation, the reason I'm focusing on this is because that's what I want you to think about. I don't want you to remember all this information. I want you to know that there is such a thing as an elder law consultation. When you need to resolve long-term care issues, you get prepared. You have powers of attorney, advance directives that are as broad as possible. Do I want you to have run-of-the-mill powers of attorney? No. I want you to have aggressive, broad powers of attorney if it's appropriate for this person. Okay? You get those basic estate planning documents in place. You have an elder law consultation. You are now availing yourself of professional advice. You're availing yourself of the planning team, and you're doing everything you can possibly do to be prepared for long-term care. It relieves anxieties and hopelessness that people have. Can you imagine being a spouse, and God forbid if one of you has experienced this, a spouse where you have a loved one who has dementia or other issues, and you feel like you're going to lose everything you have. I had a meeting with a client on the Eastern Shore about 4 months ago. She was told every conceivable thing you could possibly imagine that was wrong about elder care planning. She felt that she was going to lose her house, everything she owned. It took me, I met her at a restaurant, which I don't normally meet clients at restaurants, but it was a remote location, and it took me 30 minutes to get her to stop crying. I mean, that's how sad it was. So there's a lot of hopelessness and anxiety. There's a lot of ambiguities and misconceptions. There's a lot of misinformation. So it provides a sense of direction, gives a sense of empowerment, creates a foundation for family unity. Not all families get along, but if we have family unity, we can do an awful lot in elder law if we have family unity. And it addresses weaknesses. If there are weaknesses in the family structure, we're identifying those issues and we're trying to learn to deal with them in advance. All right, what do clients want to know when we're getting close to the end here? How can I pay for assisted living? How do I pay for long-term care? Will I lose my home? How will I survive in the community if I'm a spouse? Okay. Can we preserve any of our assets? What do I do, generally speaking? What do I have no direction here. How do I deal with the placement of my loved one? Recent situation, geriatric care managers. You've heard me say this several times. I can't emphasize this strongly enough. Use a geriatric care manager. I had a situation recently with a client with a decorated war veteran from Vietnam, PTSD, dementia, all kinds of issues this poor man was dealing with, and the family did not know how they were going to get him placed in assisted living. And geriatric care managers can be very, very helpful to do that difficult job. Healthcare decision making, we talked about that, and will I need a guardianship? Can I get veterans benefits? Veterans benefits can, under the current law, give anywhere from $1,100 a month to $2,100 a month, give or take, tax-free to certain veterans who served in the period of war, of 4 different major periods of war, not necessarily in the theater of war, but the period of war. So those are one of the first questions we ask. Is this person a veteran? Asset titling, how do I deal with the care of an impaired loved one? We live in a continuing care retirement community. We're not supposed to be able to preserve any of our assets, but can we still get VA benefits or preserve assets? It is still possible in some situations to do that. So that's a broad overview and in the shortest period of time I can give you. Again, I hope you were able to take away something